Hi, I'm attorney Greg Dell, joined by attorney Jason Macri, and we're going to have the pleasure of talking to you about one of Jason's resolved cases. And Jason, I know recently you resolved a case against Unum Insurance Company, and in preparing for today's video, you were telling me how this is one of the classic cases where we see denials happen at the 24-month change of definition. And in these videos, we like to talk about the facts of your case so that people watching this can relate to the type of clients we have helped. We also like to talk about why Unum denied them, what you were able to do to get the benefits reversed. And then while we're talking, we'll provide some tips for people so that they can learn from our videos about how to avoid a denial, how to handle an appeal, and other things that would be beneficial for them while going through the process with Unum. So let's start with the background of your case against Unum.
So our client's 62 years old. He was working as a field technician for a major corporation that does mattress deliveries. And he had a low back problem and ended up needing a low back surgery. He essentially had a fusion on his low back. His job required a lot of physical activity. He couldn't do it. So Unum paid him for the first 24 months. They agreed he couldn't do that job. Exactly at the 24-month mark, they denied him. Leading up to it, what they did was they had a nurse review all his updated medical records. And the nurse rendered an opinion, basically said she thinks he could do light duty. So they had a board certified internal medicine doctor also review everything. Of course, a board certified internal medicine doc said that he also could do light duty. And then they had a physical medicine doctor review everything, also said he could do light duty.
Okay, and then they sent a letter explaining all of the reasons why they denied your client, correct?
That's right.
And from your experience in handling hundreds of these Unum denials, is it normal or unusual that they relied on a nurse and these were their own hired doctors, right?
Right, it's not all that unusual, but they did bring a lot of firepower to this one, it seems. And, they did that more than likely because they wanted to attempt to have a strong denial on this one. But, he had this low back problem, was experiencing a great deal of pain. And just having these doctors look over medical records really wasn't telling the full story here.
So they never had him examined.
Correct. And he never saw him.
Is that something normal that you see, that Unum denies a claim without examining the claimant?
See it very often. It seems to be almost every denial has that.
You weren't representing him before that,
That's
correct?
right.
Okay, so he calls you and says, I've been denied. I got this denial letter. How can you help me and what do I need to do? What did you do?
Well, what we did was, in order to help strengthen his case, we sent him out for an FCE, functional capacity examination, and it revealed that he can't do any type of sedentary work, definitely no light duty work. He couldn't do sedentary because he couldn't sit for a significant period of time. He could only sit for a very minimal period of time. And so the FCE was also very helpful in this case. Something else that we did, we also had him go for an MRI of the low back because Unum's doctors were saying, well, he had this low back surgery, he healed up really well and didn't have any problems. The MRI that we were able to have conducted revealed that it wasn't healing as well as Unum's doctors had characterized it, and he was having post-surgical changes in his low back, and this was causing him a great deal of pain and discomfort.
What was your thought process in having him go for an MRI of his back?
Because we knew there hadn't been one in a significant period of time. And something else that's very common in low back injuries, when a surgeon performs a fusion, for example, like what our client had, the doctor's very interested in being able to say, it's healing up very well, the patient's doing very well. That's the opinion that they always want to be able to render. They want to be able to say their surgery went well. But the MRI told a picture that was different from what his actual doctors were saying.
So there is sometimes that inherent conflict of interest between the treating doctor, surgeon, and the claimant, because the doctor wants to say, hey, I did what I was supposed to do on your back, but yet you're still having these problems. And I see that almost all the time. Not that surgeries aren't successful, but I see that in the cases where someone has surgery, it doesn't necessarily alleviate the restrictions and limitations that they were having. It may help with the level of pain that they're having. But a lot of times claimants go into surgery because they're in excruciating pain or they're subject to very serious possible spinal cord impingement, they're at high risk of paralysis, God forbid something happens to them, and then they could be in a paralyzed position. So you have to stabilize their vertebrae so that they don't have any spinal cord issues, which create even bigger problems than the pain and the limitations they were having. So it's not unusual for someone to have a surgery, yet still be unable to return to, especially in this case, it was a heavy duty type job that you were saying that the claimant had initially. And then did that stay as an own occupation definition of disability?
So after the first 24 months under his policy, the definition of disability was any occupation. So we had to be able to show he couldn't do any occupation, whether it be light or sedentary. And that's really where the FCE helped out a lot, was able to show he's just not able to sit for a significant period of time. And in order to do sedentary work, you do have to be able to sit for at least a couple of hours at a time. He just simply wasn't able to do that.
So do you think, so since his definition of disability, which for people who are watching this video, the definition of disability is different for everybody, depending upon what policy you bought or what policy your employer provides to you. In this one, it was the first 24 months you have to be unable to perform the duties of your occupation, which in this case was a heavy duty type job. Then it switches to unable to perform any duty for which you, any occupation for which you have experience, education, and training. And with that, it switches to, let's just what they call a sedentary job or a desk type job. Had the definition of disability not changed for this particular client and stayed as the inability to do his own occupation, which was heavy duty, do you think Unum still would have denied his benefits?
They may have denied him, but they would have had a very difficult time there because the job that he had was one that required a great deal of physical strength and activity. And he just simply wasn't able to do that after having gone through his low back surgery and all the complications that he was having as a result of the surgery.
So I always tell our clients and people who are looking to hire us to help them with their appeal that the biggest strength of what we do is not so much in the writing of the appeal, which is has to be done strategically, but it's in the manner in which we obtain the additional information to prove that the claimant is disabled. And in this case, it sounds like you said you did a functional capacity exam through working with an expert who specializes in putting the claimant through some testing that is supposed to simulate their ability to work 8 hours a day, 40 hours a week, even though it's a 4 to 6 hour type examination that they go through. And then you also said, I really think we need some more objective evidence. So this is a specific testing that I want. And the other thing that I know that you always do that we talked about was getting a specific attending physician statement from the doctors based upon the additional medical support that you got to say, how does this additional medical evidence support the claimant's inability to work? And so those were all great things that you did. And then how do you tie this all together and present it to the disability insurance company?
And we were able to get an attending physician statement to get more clarity so that the doctor that did do the surgery could say, well, the surgery went well, but that doesn't mean that he still does not have complications. And we were able to tie it all in with the FCE results, the MRI report, the APS being completed and being favorable to our own client. We were really able to show he can't do any type of job, whether it be light, sedentary, or any type of job.
And then when you submit your appeal, do you just submit the records or is there a strategic letter that you draft that goes along with all of these things?
We drafted a pretty lengthy appeal because we wanted to make sure we included every single opinion, all of his medical records, reports, results, etc. And then we put that long letter together with an entire package of all the evidence, all of his medical records, reports, doctor's notes, the FCE results, the MRI reports, the APS. So it turned out to be a very extensive package that we filed on his behalf.
And I remember when you submitted this, reviewing it, that it was hundreds of pages, if not over 1,000 pages of information that was submitted. And can you tell people, because I always tell them about the importance of writing a strong appeal. Why is it not just to win, but why is it so important to throw everything out there on the table in the appeal? God forbid you are to lose the appeal.
Right, you really only have one shot with this appeal. It's not as if we could do another one if we didn't win this. And if you have to file a lawsuit and you're litigating a case against them, you have to make sure you made every argument in that appeal, put it into the administrative record. So the appeal is extremely important. It's way more than what an insurance company would lead you to believe, which is just write us a quick letter of how we're wrong and we'll render an opinion. You really have to make sure you put everything into that appeal.
And I often tell people, because they don't realize that if you submit the appeal and then the insurance company makes a decision, And the next day after they make a decision, I always go extreme on this, you get hit by a bus and you are decimated. You're lucky to survive, but there's no way you're going to work. That information is not admissible at any point in time whatsoever. So if you don't get all of your evidence into this administrative appeal, it's never coming in. And that's significant because there's no other area of the law like this.
Right. And it's so bewildering to people because you would think when you file a lawsuit, that's when the case really begins. Here, by the time you filed your lawsuit, you need to make sure you've done every single thing and included everything that you can.
And that's why we always tell the claimants, because Unum makes it like, hey, just go ahead and tell us you want to appeal. Yeah, we're going to have someone else look at it. Yes, we'll have different doctors look at it and maybe they'll reverse it. But it's not like that because they'll just rubber stamp what's there. If you don't put in an extensive package, there's almost no way you're ever going to get your benefits reinstated or reversed of a denial.
It's very misleading. They lead you to believe, just let us know what's going on and maybe we'll render an opinion in your favor, but that's definitely not good for the claimant.
Well, great job on this case. And now the claimant's benefits are reinstated. And I know that you continue to monitor the claim on a monthly basis to protect the client's benefits so that benefits keep coming every month. And a lot of claimants don't realize that every month Unum's reevaluating these claims because the person who we call the claim rep at the insurance company has to, I say, just push a button, but they have to approve the payment every month. So they're reevaluating it. Now, they may not ask for paperwork every month or a physician statement every month, but maybe every quarter, maybe every 6 months. And in the meantime, you, I know, continue to monitor the medical records of your client, be in communications with your client to make sure that the client doesn't get themselves in a position again where the carrier has the opportunity to deny them.
That's right. It's an ongoing process, and you're essentially constantly updating the insurance company with anything you could use to support the claim.
Well, congratulations on this victory. If you're someone out there who has a Unum disability insurance claim, no matter where you live in the country, myself, Jason, any of our lawyers are available to assist you and will always provide you with an initial free phone consultation.